Good afternoon and welcome to Venable's monthly webinar. This month's topic is the Service Contract Act, What Government Contractors Need to Know. I'm James Boland, a partner in Venable's Government Contracts Group, and I'm joined by Jennifer Flickinger, a principal at Baker Tilly. Before we get going, I just wanted to make a couple quick announcements. First, thank you for joining us, and we appreciate your participation. Your phones are on mute, so you will not be able to ask a question, but there is a place on your webinar screen that will allow you to submit questions, and we will be monitoring those throughout today's presentation. So please feel free to ask some questions.
With that, we'll go ahead. We'll talk about our agenda. We're going to start with an overview of the Service Contract Act, Service Contract Labor Standards. We're going to talk about labor mapping and conformances. Then we'll jump into DOL audit risk and exposure. We'll also talk about some common SBA pitfalls and issues, the competitive landscape, and then we'll throw in some of the other related rules at the end. So we'll start with an overview of the Service Contract Act. It was created in 1965, and it applies to the contracts for the principal purpose of which is to provide services in the U.S. through the use of service employees. So a few things there. It's for the U.S. and its territories. It does not apply overseas on military bases there. And principal purpose is defined as a simple majority of the contract requirements. This can be greater than 50% of FTEs or the value of the contract. It was created in a period where there was a perception in Congress that contractors from outside a local area were coming in and depressing the wages by underbidding the current, the labor market as it stood there. And so Congress wanted to provide protection of prevailing wages and benefits for the workers. It applies to federal service contracts that are greater than $2,500. And the contracts need to incorporate the SCA clause as well as the wage determination. It is very similar to protections that you'll see under the Davis-Bacon Act, which is for construction, and the Walsh-Healy Act, which is for manufacturing. There are certain contracts that are exempt from SCA, so it does not apply to all contracts. It doesn't apply to contracts for professional services performed almost exclusively by employees who meet the exemption under 29 CFR Part 541. This is the FLSA exemption that determines whether an employee is exempt or non-exempt. So if the contract is performed almost exclusively by exempt employees, then it would not be an SCA-covered contract. It also doesn't apply to certain commercial contracts that are specifically exempted by FAR 22 1.03. It's a very limited exemption, though. People read the commercial item exemption and they get very excited that this applies to all commercial items contracts. It does not. It does, in fact, apply to GSA schedule contracts, those sorts of things. It also doesn't apply to employment contracts providing direct service to a federal agency, contracts for the leasing of space, public utility services, federally assisted contracts for services entered into by state governments, such as Medicare or Medicaid or Medicare programs, and then work covered by the Walsh-Healy Public Contracts Act, which is for supplier manufacturing. You can, however, have a hybrid contract that has both SCA and DBA, and that is common in some maintenance contracts where there is limited construction.
I would just make one comment here. I think these exemptions are important to be aware of, and for many of you, I know those on the attendance list, you may be involved exclusively in professional services, so you would expect the SCA to apply to essentially any contract that you would be performing for the federal government, but a lot of contractors, have split contracts, and depending on the type of services they're performing, it is important to watch out for this and to know when the SCA should or should not apply. Something we'll talk about later in today's presentation includes, the importance of being involved in the solicitation process and the Q&A process. And if you see the SCA clause in a solicitation and you think that it should not apply, it's important that you do something about it. Ask the question. Notify the contracting officer that the contract, the solicitation at issue is not a services contract. It's not predominantly services. That can be depending on, sometimes it's a mistake. Or you might have a legitimate dispute with the government, but As you know from just your existing knowledge of the SCA and in today's presentation, this is a very, very expensive requirement to comply with, and if you don't have to comply with the SCA, that's to your benefit.
Talk a little bit about employee coverage. SCA coverage applies to what are known as service employees. Historically, this is really viewed as non-exempt blue-collar workers. It's important to understand, though, that on a contract, not all of your employees may be covered. What we've seen, though, recently is that DOL is applying the SCA to more professional services. So you're going to see it in IT contracts which are more of a white-collar nature that you might not have expected once upon a time to be considered SCA covered. DOL is including more and more employees under the definition of an SCA employee, and you will see that that's been broadening. The determination of the coverage is really based on job function. What is the employee doing? And that's the important test that you have to apply. Secondarily, it's the salary test. Importantly, SCA does not apply to contracts where non-exempt employees are a minor factor in the contract performance. DOL's internal guidance says that they will apply a 10 to 20% range. It's important to note, though, that this is not a hard and fast rule, and that individual DOL auditors and investigators may take a different view and apply SCA. I have seen it applied in the case where there was one SCA employee out of 100 employees, and they basically ignored the minor factor in contract performance and applied SCA anyways. So it's something to keep in mind when you're making your determination as to whether you believe that your workforce would be covered by SCA based upon the factor in contract performance. Keep in mind that the closer you get to 20%, the more likely it is that Department of Labor would consider that covered.
Yeah.
We'll talk about exempted employees next. So it doesn't apply to certain employees, and these are the folks that we talked a little bit earlier that are considered exempt under the Fair Labor Standards Act. And so there's three categories of folks there. There's executives and supervisors who are salaried. They have to make a minimum of $455 a week. They must supervise 2 or more workers, exercise authority, and spend most of their time doing so. And so if Department of Labor comes in and looks at your status as to whether folks are exempt or not exempt, they're going to sit down and talk to folks and try and understand, are they really exercising authority? Are they supervising multiple employees? And again, are they spending most of their time doing so? You have administrative and managers. These folks are also salaried. They need to make decisions of importance and significance using independent judgment and discretion, and again, spend most of their time doing so. So if you've got somebody who's constantly being directed by somebody above them as to what they're going to do, they're not using their independent judgment, these administrative folks would not qualify for this exemption. And then you've got salaried or fee-based folks who perform work. It says primarily requiring advanced knowledge, predominantly intellectual, usually acquired via a prolonged course of specialized instruction. So college level was what that was always taken to mean. A few things that we've seen happen here is that the VA incorporates in many of their contracts a list of employees that they believe are SCA covered. Those folks often include nurse practitioners, X-ray technicians, a lot of folks who actually have college degrees, but VA has said, no, we consider these positions to be SCA covered. And so that's been an interesting twist. The other thing that I have seen happen a fair amount with Department of Labor of late is that they will come in and take a look at entry-level positions that may be, say, an analyst on a contract, those sorts of things. And if they have, say, a degree in English that really isn't necessary, so the position may require them to have a college degree, but the question that DOL will say, is the study that they have that degree in, was that necessary for them to perform the work? And if the answer is no, they've often been pushing contractors to reclassify these folks as non-exempt. And once you've got a non-exempt person on an SCA-covered contract, those folks become SCA-covered.
And I would add that it's important to remember with all these classifications and determinations, the Department of Labor wants an expansive coverage of this. I mean, you take a step back and think about what's the purpose of this act, and it's to make sure that employees are paid more and receive higher benefits. And so those in the enforcement division at the Department of Labor, their objective is going to be pushing as far as they can, which is why, as Jennifer said, you see this movement, particularly in the Northern Virginia area and in urban areas where as professional services have just expanded so dramatically in the last 20, 30 years with the federal government. It's not the same. It's no longer just the traditional blue collar type positions, but it would be essentially positions that everyone would think of it instinctively as white collar positions. But that's no longer just the easy or simple test. So
yes. There are also certain classifications of employees that the Service Contract Act doesn't apply to. I don't want to read this slide, but I do want to highlight two. The first is teachers, and there can be some confusion here because if you've got an instructor position on a contract, sometimes folks align that to a teacher position and say, oh, that's not covered. The important part of the teacher's exemption is that they're performing their work for an educational institution. So if you are a professional services contractor and you are providing an instructor to the military, that's not for an educational institution, and so those folks would be covered. The second one that I want to talk about is computer employees. And so Department of Labor has recognized that there has been some change and development in the computer field that maybe their positions haven't kept up to. And so what they've done, and it's not via the law or the rule anywhere, it's actually via a note on the wage determination, is that they've said that if you've got computer employees performing higher level duties, so they're talking about design and development work with significant responsibilities, and they're paid no less than $27.63 an hour, then they would not be covered. So there's a wage level there that they're saying, okay, if you have higher level duties and you make this much money, that SCA doesn't apply to you. Let's talk a little bit now about the compliance requirements. For better or for worse, these are extremely detailed, and the devil is in the details from a compliance standpoint. But each contract has a wage, at least one wage determination attached to it. And when the PDF of the deck goes out, there's an embedded PDF that gives a sample of a wage determination. But what the wage determination does is it stipulates the minimum requirement for wages, for benefits, and there's three types of benefits that are included: health and welfare, vacation, and holiday. And then it also says administratively that you contractors need to post a poster. It's the wage and hour 1313 and the applicable wage determinations in a prominent area at the work site. Now, this can be problematic for contractors who are either working on site at a government facility or who maybe have folks that are working remotely and not in the same building. What we say here is that it's best to place these things. You do need to make sure they're placed so you don't get this technical non-compliance against you, but place it on an intranet website that the employee would access frequently, whether it's their time reporting website, something like that, so that you're technically in compliance with this posting, recognizing that the old idea that you would just post it in the employee lunchroom may not work for all employees. So wages can be paid by hourly rates, by salary, piecework, bonuses, some combination. Truthfully, the easiest and the most practical way to make sure that you're in compliance is to pay employees on an hourly basis so that you're not having to do these calculations regularly where you're figuring out, did they get paid the equivalent of the minimum hourly amount? You also, and this is really important, you must be able to document all hours worked and demonstrate that the SCA rate or more was paid for each covered hour. In the absence of good documentation, the Department of Labor will actually consider all hours worked to be covered SCA hours, so it's really incumbent upon you, the contractor, to make sure that you're doing a good job of your hours documentation. Health and welfare is probably one of the most complex areas for contractors to comply with. The current WDs establish minimum benefits of $4.27 an hour for all covered labor. The exception is Hawaii, where there's a state prepaid health care act, and you have some WDs with smaller health and welfare amounts. You as the employer can comply with the health and welfare in multiple ways. You can do a cash payment at the health and welfare rate. This has traditionally been sort of the easiest way to do it. They worked 40 hours, they get 40 hours times $4.27 an hour. You put the extra amount on their paycheck, so you're good to go. Bona fide fringe benefits, or a combination of the two. When we talk about bona fide fringe benefits, it's important that these, I'll quote, constitute a legally enforceable obligation, and they have to meet certain criteria. So they need to be specified in writing and communicated to the employees. The employee needs to know that they're receiving this benefit. You can provide for the payment of benefits to employees on account of death, disability, retirement, medical expenses, extra unemployment benefits, those sorts of things. An important thing here is that these are not things that are otherwise required by law. So your FICA, FUI, and SUI do not count towards these benefits. These are above and beyond those. It is important that there's a definite formula for determining the amount contributed by the contractor and the benefits received, and the contributions must be paid irrevocably to a trustee or third party. What this means is that if you were self-insured for your benefits, you need to actually go to the Department of Labor and request approval for your self-insurance plan to count as a bona fide benefit. And because if not, the benefits that you're providing via that self-insurance plan cannot be used to meet this 427 an hour requirement. So typical health and welfare benefits, you're going to have your life, your disability, your health, dental, vision care. You can have sick leave. Now, an important note here is that in new contracts, which we'll talk about the new sick leave for federal contractors, it would have to be sick leave above and beyond that new requirement. You can have employer contributions to 401k or other retirement savings plans. Important note here is that non-vested 401k contributions do not count as a benefit, so you can only count it when the employee actually owns that money. If you provide jury duty or bereavement leave, these things can count towards health and welfare. But again, certain things that are not considered bona fide, unfunded self-insured fringe benefits, where contractors simply make an out-of-pocket payment unless it's been approved by the DOL, benefits required by law, and payments for conveniences that are considered to be for the benefit of the contractor, such as a relocation experience. One thing that's interesting when we say benefits required by law, DOL has stated in their interpretation that even though the Affordable Care Act is a legal requirement that companies have to comply with if there's if they meet the size requirements, etc., that does not actually, that can count towards the 427 an hour. And it was interesting when Affordable Care Act passed, we didn't know which way they'd go with it because there are two different, they already have two different precedents out there. You have Hawaii, where employers are required to provide health insurance if they're above a certain size, and in those cases they reduced the health and welfare amount. And then you have Pennsylvania, or excuse me, not Pennsylvania, Massachusetts, and under that model, the Department of Labor said, no, that doesn't actually reduce the 427 an hour amount. So there are different models out there. The Department of Labor has come out and said that, yes, you have to comply with the Affordable Care Act, but that we are not reducing the 427 an hour amount, but you can use whatever insurance you provide to comply with the Affordable Care Act to meet the 427 amount. Holiday is another fun one here. So the wage determinations specify the number of holidays owed, and then they also list specific holidays to be received. So New Year's, July 4th, President's Day, those sorts of things. You, as the employer, however, can comply by providing a different designated holiday list that's on the WD. So a lot of government contractors do not provide President's Day or certain other holidays, and so it is okay for you to say that we will provide you with 7 set holidays, and here they are, and 3 floating holidays, as long as you're meeting the total number of holidays owed and you've communicated to them what that holiday schedule is. It is important, though, if you decide to do it via this combination of stated holidays and floating holidays, that at the end of every year that you're doing an analysis or a true-up to make sure that people actually took those floating holidays, because if they did not, you as a contractor are going to need to pay them out for those holidays. An employee is entitled to the holiday if they work in the week a holiday occurs. So part-time employees, this is where it's interesting here, if you're eligible for holiday pay commensurate with the regularly scheduled work hours in the week the holiday occurs. So if you were scheduled for 20 hours, then you would get 50% of that holiday. Taking a look at the actual schedule of every employee can be difficult for most contractors. So many will establish a rule, for example, that they'll look at the average amount of work that the employee did over the last quarter. And if over the last quarter they worked a 60% schedule, then they would get 60% of that holiday. As long as you've got sort of a standard that you're following, Department of Labor in general accepts that estimation policy. You're not entitled to the holiday pay, though, if the holiday is not named in the WD. This can be a big one here in D.C., especially around, say, the inauguration or Christmas time, when there's a presidential proclamation that we're going to shut the government for 2 days, or there are going to be half days, those sorts of things. That is not required to be a paid holiday for your employees. It can be difficult, especially if you're operating in a government facility, because you may not have access to that facility for working, but you as an employer then need to decide whether this is going to be extra pay, an extra holiday, or unpaid leave, those sorts of things. You cannot enforce a use or lose policy. If the employees do not take the holiday, then they will need to be paid out for it up to the number of holiday days that are described on the WD. Vacation is also one that is difficult for companies to comply with, primarily not because companies have a problem issuing or giving vacation to their employees, but really because of the methodology that's required by the WD, and that it doesn't match very well with what's most common in industry, which is an accrual methodology. So what the WDs say is that an employee is entitled to X amount of vacation after X years of service. And I say X because typically it's after 1 year you get 80 hours, but there are wage determinations that say things differently. And so what happens is that each employee is assigned an anniversary date. That's either their date of hire onto the contract or a predecessor contract, or hiring into the employee, into the company as a whole. And so if my anniversary date is June 1st of 2016, I actually was not entitled to any vacation until June 1st of 2017. And so on June 1st of 2017, I now have a bank granted to me of 80 hours. This is how technically the wage determinations are written and how you technically apply. There is no use or lose, and your vested balance has to be discharged at the next anniversary date. So let's fast forward from that example. It's June 1st of 2017. I've earned 80 hours. Next year on June 1st of 2018, my company needs to look and see, did I take all 80 hours of vacation or not? And if I didn't, I need to be paid out for the delta between whatever I took and whatever I was owed, that 80 hours. Again, this is not the way most companies' policies work. And so you can apply and sort of fit your accrual policy into this, but it's going to require some sort of annual reconciliation to make sure that you're paying folks out for the right amount, that you're accruing at the right level, those sorts of things. I do have some companies that I work with that have decided that they will, instead of doing a payout, they will continue to let the employees hold that in a bank. And generally, the DOL, while it's not technically what the rule says, generally the DOL will not take issue with that as long as there's no cap on it, and the employee always has rights to that and would be paid out at termination for whatever is in that bank. So your years of service is determined by the total length of time that an employee either works continuously for your present employer or works continuously for predecessor contractors who perform the same services at the same facility. I have seen some issues before where there is some disagreement around what similar services mean, as well as quote-unquote the same facility, because out west especially, you've got some military bases where you can actually cross counties on the same Navy base, and is that the same facility, or is the facility the aircraft hangar where they're working, those sorts of things. So those can be areas where you may need to sit down and work with your contracting officer to define. Keep in mind that the Department of Labor will always take the answer that is the best, in their mind, the best answer for the employee, and gives them the longest years of service.
All right, and thanks, Jennifer, for that really detailed dive into some of the minutia of the Service Contract Act. And I think one of the overall impressions that I think is apparent is the need for contractors to document and to have a very robust record-keeping system. And you can see, and we'll talk about shortly, enforcement actions from the Department of Labor when it can be a nightmare to go back and try to figure this stuff out after the fact. And I think we can both agree that when contractors do not have a good system in place to demonstrate what they did pay their employees and how they satisfy the vacation, the holiday, the health and welfare, all of these individual requirements. Trying to recreate that after the fact can be incredibly expensive, and maybe more importantly, ultimately, the contractor risks some of the sanctions that can be very severe. So I think the bottom line lesson on just what we've discussed so far is it's critical to have a robust record-keeping system. We're going to turn now to discuss contract price adjustments. And I know this is an area where as a contractor you're dealing with this. So you have compliance on one hand, but you also want to make sure that you're being paid and compensated for complying with the SCA requirements. And the wage determination that's current on the anniversary date of a multiple-year contract or the beginning of an option is supposed to apply to the contract. The contracting officer should modify the contract to incorporate that new updated wage determination. And the bottom line is you ought to be paid for that. And there's a mechanism to be paid under the price adjustment clause to receive an adjustment to comply with any wage change or other change associated with the new wage termination. These also should be incorporated if there's any significant change to the scope of the contract, and at a minimum no less than every 2 years. Again, keep in mind that the purpose of this act is to make sure that you're paying the prevailing wage to employees. So as time passes, presumably the prevailing wage for that local market is increasing, and you would expect that the wages that you would need to pay will be increasing. An important note to keep in mind on the price adjustment clause. First of all, make sure you notify the government right away. The price adjustment clause states that you have 30 days to do that. It's important that you get that in quickly and notify the government that your contract price actually will increase as a result of the new wage termination. Don't sleep on your right. Don't overlook it because you risk not getting the adjustment that you would otherwise be entitled to. The other point that I think that's an important takeaway here is that the adjustment here is a dilutive adjustment. It does not entitle you or include G&A, overhead, and profit. And that's different from what we're going to discuss in the next slide, which is an equitable adjustment. So the idea here is that when you are required to increase your payment to your employees as a result of a new wage determination, you shouldn't benefit from that as a contractor. That's why these other items are excluded. It's really just to make sure that your true cost is compensated. So essentially a pass through to the employees here. But it's important to be aware of this, and you ought to notify the government if they fail to include the wage termination. It's something that you need to monitor, and do not expect the contracting officers to be organized enough or frankly knowledgeable enough to monitor this on their own.
Yeah, and if you do need to go request that wage determination, you're coming up in an option year, you haven't received anything from the government, I highly recommend that you do it in writing so that there's a paper trail should there ever be a Department of Labor issue.
Yes, and that actually touches, Jennifer, on a theme that I think we both agree. It is always to your benefit as a contractor to have a paper trail of your effort to comply with the SCA. If you are particularly when there's a disagreement and dispute about whether something is covered, remember the Department of Labor will always take the employee's side on any of these close calls. And there's a lot of gray areas in this area of law. So you could expect that Labor and their enforcement division will always take the employee's side. And when it comes to enforcing severe sanctions against a contractor, one of the most helpful things that you can produce is a paper trail of your effort and intent to comply. What Department of Labor does not like, and really the companies that they really go after, are those contractors that show an indifference to the Service Contract Act, that they show a disregard for the higher wages that they should pay the employees, and and even if it's not an intentional disregard, it's just that general lack of concern, and so all this point, I mean, I think it's just, I would emphasize repeatedly, be proactive in trying to comply. On the next slide, this is an interesting provision in the FAR. It's not in this. You're not going to find this in the Service Contract Act related clauses, but you'll find it in the FAR. It's FAR 22-1015, and this is a provision that essentially provides that if the Department of Labor discovers that an error, that a contract was supposed to include the Service Contract Act clause the SCA was supposed to apply to the acquisition, or did not include the appropriate wage termination, you as the contractor have a right to an equitable adjustment to account for that error. And this is different from the adjustment that we referred to in the previous slide under the Price Adjustment Clause, which is for your run-of-the-mill new wage determination or updated wage determination. The equitable adjustment should include the other items like G&A and overhead and profit. And again, the idea here, you sort of think about why. If you submitted a proposal in response to an RFP and there was no SCA clause in the contract, nothing indicated that this was a service or that you as a contractor would be obligated to comply with this complex statute and system. Not only would you be entitled to, should you be entitled to an adjustment for the actual wages, but I think also just the rest of the indirect costs. It's to really make the contractor whole here when the government makes the mistake. The Department of Labor can also apply this retroactive to the beginning of the contract as well. So, and frankly, as a contractor, I've seen situations where contractors do not want to deal with that because it can be highly complex for you to figure out how to go back and apply the Service Contract Act, particularly if you're talking about 3 or 4 years and you have employees that have long since
former employees, or God forbid a change in your accounting system, your payroll system. All of this can make it much more difficult to do.
Yeah. So you can imagine that even though you're made whole, there can be some resistance. I mean, certainly, I think that the general proposition that this is an opportunity for you and your employees to get paid more. Generally, that's something that I think that contractors should pursue. If you can, and convince the Department of Labor and the contracting officer to apply back to the beginning of the contract. I mean, in an ideal world that you could do that. Although I do understand because of the complexities, it could be just an absolute nightmare. And there are provisions if you've got former employees that you no longer have information, how to reach them, addresses, banking account information, things like that. When you've done your due diligence and you've failed to do it, you are then supposed to actually make a deposit to the Department of Treasury, and they will technically hold those funds to you so that if the employee ever surfaces, that they could then be made whole. Just as an anecdote, as an example where I've seen where this has become just a real challenge to comply with is when there's a retroactive application, the SCA didn't apply, but the wages paid were either in excess of the wage termination wages, or for some employees maybe just on the line. So we're talking maybe a 10 or 15 cents, so it's sort of a de minimis change. That might add up to $100 or $200 an employee over 3 years, and it just becomes the time spent going back and trying to find everyone can be a challenge. But this goes back to an earlier point, though, which is you as the contractor should have a good sense if the contract is predominantly services. There's no reason why you can't bring that to the government's attention in advance, so you would avoid this at the outset. next slide that we're going to discuss is labor mapping. This is a continual challenge in terms of compliance. My assumption is you at least have some familiarity with the Department of Labor's Directory of Occupations. They publish a directory that describes the various SCA labor categories and their basic job descriptions, and general clerk, word processor are common examples, and you might see general clerk level 1, level 2, or level 3 is a common way that the directory will classify different basic, intermediate, or advanced experience or skill levels for employees. Every employee on the contract has to be classified according to the directory of occupations. So you look at an example of the wage termination, you see all the job categories and they correspond to a certain direct labor rate. You have to do the mapping yourself. Sometimes you will see the government in the solicitation include the mapping for you, or maybe they'll provide the mapping from the predecessor contract. But ultimately, it is your responsibility as a contracting officer to conduct this mapping and to make sure you get it right. This can be tricky for a number of reasons. A lot of times, you see confusion quite a bit. A lot of these large IDIQ contracts have descriptions of positions that seem to conflict with the Department of Labor's the titles they use. A general clerk or as an administrative assistant, or they can mean very different things depending on what the contract is for. And it's not a black and white issue. You have to look. Ultimately you have to look at what are the job functions that the employee is performing. You cannot rest solely on what the contract says the person is supposed to do. But Department of Labor is going to ask, what is this person doing on the contract? You may have hired someone as a general clerk level 1, because that's what the solicitation, or that's what the PWS tells you the role is, and that was the job description that you used for your recruiting effort, and you hire this person, you even give them that title. But if once contract reforms and they start performing duties that fall within the description of general clerk level 2 or level 3, then they are a level 2 clerk or a level 3 clerk for SCA purposes, and you have to pay them that higher wage.
The challenge here is that the Directory of Occupations has not been updated well. It is very general when you go and read these descriptions, and that can make it really, really hard to find the right position. One of the most common FCA-covered positions is the help desk, the person who's answering the phone, whether it's an IT help desk or an insurance help desk. There is no help desk position in the Directory of Occupations, so that leaves employers with the challenge of finding the best fit. And that becomes the art of labor mapping versus it being a science. Or then conversely, doing a conformance. So if you say there just is not a good labor mapping here, I need to create a position in my wage determination, there's a process by which you can submit a conformance. But that process can be time consuming. You have to go through your contracting officer. The contracting officer then forwards it to the DOL. And not all contracting officers are as open to a conformance as others. And so, that's an administrative headache that they may not be thrilled with you for putting on their plate. And so a lot of times there is a struggle internally at a contractor as to whether we're going to just make our best guess mapping that we think is about as appropriate as we can get, or whether we're going to submit a conformance.
Yeah, and one other point that I wanted to make on this slide, I think that we mentioned that you cannot split the labor classification duties. You can't come up with sort of a hybrid rate on your own. So if you think it might be a clerk level 1 or a clerk level 2, and the difference is $20 an hour or $25, and you think that person is going to split their time between the two positions, you can't come up with a $22.50 hourly rate. That's not going to work. So they have to be classified under one of those categories. Now, you can have splits between different classifications. So, for example, if one employee is spending 80% of their time, performing word processor duties, then 80% of their pay has to be in accordance with the word processor classification or corresponding rate for that classification. And if 20% is a general clerk, then 20% of their pay has to be at that rate. Generally you tend to pay just the higher rate. You can get down to that breakout if you can document it and demonstrate it, which is in most cases is almost prohibitive administratively. It's not cost prohibitive. It's just not worth the effort, and so you are going to just classify them at the higher category. Jennifer mentioned the conformance as an option. Keep in mind, if you look at the directory of occupations and you don't find a position, you still have to pay a prevailing wage. So whether you are struggling to find what that position is, that's not an excuse not to find out what the prevailing wage is. You have to do that. There is going to be a right answer somewhere, according to the Department of Labor. Don't just take the easy way out and say, well, this doesn't really fit within the directory that I'm looking at, so I'm going to give what I consider to be a market rate, or this rate's above market, so this is going to be fine. You've got to be able to explain and justify that.
Yeah, and once you submit that conformance, you need to be paying at that conformed rate, even though it hasn't been approved by Department of Labor. The assumption is that it's approved until you hear back from them. So, if you do go down that route, keep that in mind. We'll talk a little bit now about DOL audit risk and exposure. What we've seen over the last 5 to 10 years is that SCA enforcement is on the rise. That the government hired actually back during some of the construction activities that were funded by Congress. They hired these additional investigators. As that DBA related work has gone down, they've sort of reassigned them to working on SCA cases. An important thing I want to point out is that the change in administration has really had no impact on the aggressiveness of local auditors because, frankly, there's not as many people that have been placed into the senior level positions. There is nobody there that is sort of changing the tone of the view of the Department of Labor. The individual investigators are really out there without a lot of leadership, and so they are continuing with the same mindset that they had under the previous administration. We have also seen a slight increase in targeted versus complaint-driven investigations. So historically, the way that it always worked was that an employee would complain to the local DOL office, and that would trigger an investigation. We are seeing that there are certain industries that they're realizing that, we're seeing a number of contracts maybe that are IT related, that the contracting officers haven't been incorporating the wage determination. So let's go and knock on the doors of some of these contractors and figure out whether these are actually covered contracts that have been missed by contracting officers. So Department of Labor is getting a little bit more targeted there as well.
Yeah, and I would say, in terms of what does an enforcement look like? You will hopefully not, but I would imagine that most on listening in today have had some interaction with a wage and hour investigator, asking questions, requesting payroll records and documents to determine if you are in compliance. And as Jennifer mentioned, a lot of times these are targeted investigations. A lot of times these are prompted by employees who feel that they are not being paid what they should be paid, and have notified the Department of Labor, which then begins an investigation, fact-finding. And remember, the Labor Department will almost always take the employee's side. They'll believe anything the employee says for the most part. And employees tend to or have been known to exaggerate or embellish the the complexity of the work that they're performing. So it's not uncommon for employees to tell the Labor Department that they have these really high, complex responsibilities, and they should be classified at some higher category position, and that can be obviously problematic for you if the Department of Labor then pursues an enforcement action. But once the Department of Labor, if they feel that they've gathered enough information from interviewing your employees and perhaps looking at your payroll records, they will or can, essentially what it looks like, they will file suit against you. You will receive a complaint from the Department of Labor seeking to recover these wages, and we'll discuss next what some of these sanctions can look like.
So by statute, the law actually says is that if you have violated the SCA, that you are subject to a 3-year debarment absent proof by the contractor of quote-unquote unusual circumstances. In practicality, the Department of Labor does not usually debar for 3 years a first-time offender. They will usually look at the facts and circumstances and work with the contractor to make sure that you're making back pay, potential interest, those sorts of things. If they're extremely bothered by the behavior of the contractor, but they don't want to actually debar the company, they may terminate the contract for noncompliance and recompete it. What we've seen when we look at debarment, though, is that they're usually going ahead and proposing debarment for companies or individuals that they consider to be bad actors, folks that have either done it repeatedly or, frankly, the violation was so egregious that the contractor clearly knew what they were supposed to be doing and didn't do it. So, for example, there was a moving company, I believe it was actually out of Maryland, and they were well aware that they had an SCA contract. They were actually filing for the annual price adjustment as a result of the new wage determinations, but they were not paying the employees the increased wages. So that's a pretty egregious violation. I'm going to go ask the government for more money that I'm owed because these employees are supposed to be paid more, but I'm not going to actually pay the employees. In that case, they did a debarment. I believe Restaurants Associates, which was a pretty high-profile case, regarding the dining services on Capitol Hill, they've been proposed for debarment because my understanding is that the Department of Labor took a look at the violations and found them to be so systemic that they felt that this was a case where debarment should happen. There have also been there's a recent Davis-Bacon Act, so a related law, a criminal case for false certifications of payroll. So be careful what you're giving to the government, what you're certifying to, those sorts of things, because you may not realize that you could be tripping yourself up in some of these areas.
Yeah, and I would add, Jennifer's right that in practice that debarment is I think understood to be more appropriate for the truly bad actors who are out there to take advantage of their employees. Not the contractors that, like most contractors, who have legitimate questions and confusion about the application of this act. You guys want to do right, but you may not fully understand that the wages you're paying are not exactly in conformance. But I will say. That's in practice, but the law itself is harsh. Mm-hmm. The law provides for a presumption of a 3-year debarment, which is frankly, it's pretty extreme. And the normal, I would say that this is far more draconian than your traditional government contractor suspension debarment provisions, because at least with suspension and debarment. For other bad conduct that a government contractor may engage in, you have the opportunity to demonstrate that you are presently responsible. You can come clean and work out an agreement and demonstrate that debarment is not appropriate. Debarment is not meant to be punitive in the broader sense. But here, under the SCA, this is statutory, and 3 years is a long time for an error. So it is really important that you take this seriously. And this goes back to something that we mentioned at the beginning of the webinar. This is why it is to your benefit to have a paper trail of your effort to comply with the SCA. internally your effort, your attempt to classify, to map categories, and explain why. If you are going to categorize a certain position under a certain occupation in the directory, have some document that explains the justification for that up front. If you have questions about a new wage termination, or you think it ought to be part of the contract, you have these emails to the contracting officer asking that the government modify the contract because you want to pay these higher wages, you want to provide. So all of that, I think, helps paint a picture that's going to work in your benefit. So in the worst case scenario that you are subject to an investigation, the Department of Labor can see that, and I think that all helps to mitigate against debarment. And ultimately, I think one of the goals here, even if you do receive a lawsuit from the Department of Labor, typically this is something that can be worked out, that you can settle this, and essentially, usually it's to make sure that you pay the employees what they're owed, what the Department of Labor considers that they're owed. The Labor Department is usually not going to want to settle, in terms of allowing you to pay pennies in the dollar, because again, their goal here is to make sure that the employees are getting paid. But in my experience, I think Jennifer, in your experience, the Department of Labor is not so committed to the department that they're going to go after it just for the sake of doing it.
Yeah, one of the challenging aspects here is that really, I often say, Department of Labor is judge, jury, and executioner here. They have the final decision. There is no external government department that you can go to and appeal. All of your appeals will be within the Department of Labor, and they don't apply a materiality threshold for exemptions. The last bullet here, we have voluntary back pay versus settlement with DOL versus DOL enforcement, and there's some decisions to be made. If you identify that you were non-compliant, you as a company need to figure out, am I going to make a back pay voluntarily to my employees? Am I going to disclose this to Department of Labor? Do I want to just correct this going forward and hope that I don't end up with a DOL enforcement proceeding, those sorts of things. And there's pros and cons to all of those. This is where I would definitely put a plug in for legal counsel and say you need to get legal counsel involved so that you understand what the different options look like here. One thing is that if Department of Labor does come in and do an investigation, their standard look-back period is 2 years. So if you want to do a voluntary back pay yourself, it probably behooves you to look at things going back 2 years. But oftentimes if you actually take it to Department of Labor and you settle formally with them, there's two benefits that can happen there. One is that they will often allow you to offset. If you had an overpayment in salaries and an underpayment in health and welfare, or vacation you underpaid but holiday you overpaid, they will often allow you to offset that, even though the rule itself doesn't allow that. In negotiation, they may allow that. The other thing is that if you have a settlement with the Department of Labor, this back pay becomes an allowable cost to your contract. If you do it voluntarily, that cost is an unallowable cost to your contract. So these are some of the different, depending on the dollar amounts of the back pay that may be involved, the number of employees, you need to understand what your workforce is like. Are they likely to, if you tell them that SCA now applies to them and you're going to, here's their new benefit rate or here's their new pay rate, are they likely to look at you and say, well, why didn't you you haven't been paying me that way for 2 years, and so I'm going to go complain to the Department of Labor. These are things that you need to sort of take a look at and analyze your independent situation. So we'll talk through some common SBA pitfalls. I think you'll hear a bit of back and forth from James and I here because we've both seen these at various ones of our clients. One of the most common is that part-time or temporary employees are mistakenly ignored during the assessment of SBA coverage. It does not matter if somebody is a 1099 independent contractor. You are still required to provide them the same pay rate and health and welfare and holiday and sick pay. If they're an independent contractor, that probably means that you're providing them cash in lieu of these things, those sorts of things. But you need to make sure that you are paying them in full compliance. If you're using temporary employees, it makes sense to go find a temporary agency who understands the SCA and make sure that in your agreement with them that you have flowed down these requirements to them. Unlike Davis-Bacon Act, which allows you to commingle, under SCA you cannot commingle wage and benefit amounts. This is oftentimes, it's a very common mistake where the presumption is, well, the pay rate is $20 an hour and I'm paying them $30, so it doesn't matter that I'm not providing $4.27 in benefits because I'm compensating them at a rate higher than what would have been $24.27. The way the rule is written, and technically if Department of Labor does an investigation, you cannot commingle. You need to show those payments separately. Benefits are included that are not bona fide, gym memberships, things that are for the benefit of the employer, uniforms. A lot of these things aren't really considered to be bona fide benefits, so you need to make sure that you're taking a hard look at that. I think we mentioned earlier things that are required by law, so your FICA, FUI, SUI that you pay on behalf of those employees. Those are not bona fide benefits. The next one's a little bit more general. I like to say that SCA compliance takes a village. I get asked all the time by clients, who's the one person that's most commonly responsible for SCA compliance? Unfortunately, the way the rule is written, there is not one person that's responsible, and so oftentimes it's a lack of communication between departments that leads to the SCA non-compliance. Whether it's that the bid and proposal folks didn't realize when they were bidding on the contract that it was a covered contract. The contracts folks maybe didn't communicate to the program manager running the project that it's an SCA covered contract. There weren't good rules about time reporting and things like that. So, you know, it takes a village, and it takes everybody from the employer, the individual SCA employee to their management groups and their supervisors who should be reviewing their timesheets, making sure that they're coded appropriately, to your contracts, your payroll, your finance, your bid and proposal folks. So really making sure that that communication is set up can help prevent a problem there. Another one is subcontractors fail to comply with the SCA. Technically, the way the rule is written, if your subcontractor fails to comply, the Department of Labor can hold you, the prime, accountable. Now, most commonly, they will actually go to the subcontractor and try and make them comply. However, what can happen is that if a sub, especially if you've got small business subs, if they don't have the financial wherewithal to make the payment to the employees, you will find that the prime contractor is the one being forced to make that payment to the employees. So it really does behoove you to make sure that your subcontractors understand SCA, understand the requirements. If they are giving you a bid that's SCA covered and they're using a general clerk 3 who makes $15 an hour and $4.27 on benefits, and the rate that they're charging you is $20 an hour, there's very little chance that they're actually complying. Have that discussion with them. Make sure they understand those rules. The smaller the business, the more time you need to spend with them helping educate them as to these requirements.
Another common pitfall is when the contract contains the Service Contract Act clause, but there's no incorporated wage determination. And the wage determination is really the document that tells you what wage and fringe benefits you need to provide. And so without that in the contract, the contractor is left in this gray area where the contract says under the SCA clause that you have to pay the prevailing wage to your service employees, but there's that prevailing wage is not determined because in the sense that the wage determination is not part of the contract. So, I mean, this is an area where you need to communicate. This ought to be addressed in frankly the solicitation phase, but it's something that you need to communicate with the government and not overlook the fact, not just ignore the fact that, well, you know, there's no wage determination, so we're gonna go on and pay what we want. That can get you in trouble. Failure to segregate your SCA hours from commercial time. This goes to, I think, a common theme and a common pitfall is just the general lack of documentation. And I'd relate that similarly to the next bullet of employees performing multiple functions. If your employees are not are performing functions of the company in different hours, that needs to be documented. You need to have a very clear tracking system that can show when they're performing the SCA covered work and when they're not. Another issue that I see, and it always concerns me, is when contractors wait for an adjustment before paying the minimum wages. They're looking for the contracting officer to first put the money on the contract and pay the contractor, and then think that they will then make their employees whole later. This goes to I think one of the core themes and why this is a challenging law to comply with for contractors. The Department of Labor is solely responsible for enforcing the SCA, not your procuring customer, the contracting officer. Those are two different organizations, and so the contracting officer is responsible for the contract terms and payment, but not enforcement of the SCA. And this is where I think you can really stumble. If you have, the Department of Labor is going to have little patience with you as a contractor if you refuse to pay your employees the wage they're entitled to because the contracting officer hasn't put enough money on the contract to make you whole. And now sometimes, depending on your side, this could be a deal breaker. You may not have the means to do that. My advice and recommendation is that is a matter between you and the contracting officer. That becomes a basis for a claim, some contract-related action against the government, against the contracting officer, if they fail to, if they do something or fail to take enough action or provide the funds in time which cost you more money. That could potentially be a change. There's other avenues, but the problem is the Labor Department, for the most part, is not going to have much sympathy because I've heard them say that. They will say that to you. That's not my concern. I don't really care what the contracting officer says. That's between you and them. That's not our world. The second to last bullet on this slide: classify employees based on the contract description versus the actual work performed. This goes back to what we talked about with mapping. That's an issue that I see quite a bit where the mapping is done based solely on the written description of their work in the contract, and there's logic to that. It makes sense. In fact, that's probably how you bid the contract, because unless you're the incumbent, you wouldn't really know the details of the work that these employees will be performing. But the Labor Department expects you to pay and requires you to pay under the SCA the prevailing wage for the work in the category that corresponds to the work actually performed. If you come across a situation where you bid the contract based on one description and the actual work turns out to be different than described, my recommendation is that you think carefully about a potential claim against the procuring agency under the changes clause, where the PWS did not accurately describe the job duties and the different responsibilities of these positions. But that is a separate issue. That's a separate issue that you need to take up with the contracting officer. But under the normal disputes clause, under the CDA, that will get worked out in some way. You're either right or wrong, but if you're correct that the contract description was incorrect, you'll get paid eventually for that. But in terms of complying with the SCA, if your employees are performing certain work, you've got to classify them according to that work. The final bullet that I would mention is the and common pitfall is when the SCA clause is buried somewhere in the master IDIQ contract, but it's not in the task order. And this can happen particularly on these large IDIQs when the task order itself has a full solicitation. It looks like a standalone acquisition with all of these clauses and incorporated by reference. You have a task order solicitation with no reference to the SCA, no wage termination. There's no hint that the government is treating this large task order as a service contract. But in your underlying master IDIQ vehicle, the SCA clause is there. That gives the Labor Department the opening they need to pursue an enforcement against you. So be aware of what clauses are in the master contract.
And I just want to build up something. James mentioned the fact that Department of Labor will not care that the contracting officer has, not made you, the contractor, whole, and they're still going to expect you to pay the employees. Sort of tangentially related to that is the fact that your relationship with the contracting officer, it doesn't matter that it's wonderful, it will not protect you from the Department of Labor if there's an investigation. The contracting officer is powerless really against the Department of Labor. I have, in all the years I've been dealing with SCA, I know of one situation where a contracting officer told Department of Labor to pound sand that they would not incorporate a wage determination. But that's extremely rare. In general, if the Department of Labor says that the contracting officer is to incorporate this, the contracting officer does it, because the way that the rules are written, that is Department of Labor's decision and choice.
Yeah, that's a great point. I mean, it is Labor Department's prerogative, and that's a great point. And I don't know if we mentioned, but even the payment withholding, which is one of the immediate enforcement options, the Department of Labor will tell the contracting officer to withhold funds if they determine up front that there's a non-compliance, before you even have a chance to litigate and dispute that. The procuring agency, your friend, the contracting officer, is obligated to withhold those monies. I mean, they will keep the funds essentially in escrow until it's finally resolved and released by the Labor Department. But the Labor Department gets to call the shots.
Right. On slide 21, we've got a form. It's called the WH56, and this is just here so that you're familiar with what it looks like. So even where the back pay wasn't the fault of the contracting officer failed to put in the WD or the WD in the clause, whatever, the Department of Labor will issue a wage and hour 56 form. They may take credit for back pay wages according to this form on their website. Whether or not it was your fault as a contractor, they will take this form and they may write up a little blurb that they found these back wages. Even if you come to them and you present the non-compliance and the back wages, they will likely fill out this form. The one good part about that is that, and the form really doesn't make a determination or distinction between why the back wages were owed and whose responsibility it was. The one good part about this form is that if you have signed this form, it's part of a settlement. So any amounts that are the back wages on this form would be considered allowable. And this is where you, the contractor, agree with the Department of Labor as to the amount per employee that is to be paid for them. We'll take a little bit at the competitive landscape. A lot of these SCA contracts are not high margin contracts. The smallest amount of money can make the difference between who wins and who loses these contracts. And so one of the most important things to keep in mind is that the manner in which fringe is paid can have a significant impact on your price. Historically, paying cash in lieu, it was just the easiest way to do it. A lot of contractors did this. But over time, more sophisticated contractors started realizing that they could actually have a lower price simply by providing benefits instead of cash in lieu. Because if you provide cash in lieu, that is subject to statutory fringes. And even though it's only 5% of these health and welfare dollars, and you might be thinking they're not very big, it can be the difference between winning and losing. The other thing is that with the Affordable Care Act in play now, if you are required to provide ACA insurance, you wouldn't want to pay cash in lieu and not take credit for what the insurance that you're providing under Affordable Care Act. It's also not in your benefit to not provide the required insurance under the Affordable Care Act and pay those fines and penalties, because those become unallowable costs to you, the contractor. One thing that's out there, though, and this is a discussion I've had with a number of clients, that if you go from paying cash in lieu to providing benefits, that this can be an employee relations issue, and it's something that you as the employer will have to sort of navigate carefully. Under the SCA, it is the employees can go complain to the Department of Labor that you're not providing cash in lieu anymore, that you're providing benefits. It is at the employer's prerogative as to what benefits they wish to provide, as long as they're bona fide. But there's oftentimes some communication and warning that needs to happen, because for better or for worse, for a long time in many wage determinations, the statutory wage has not been changing. It's been pretty flat, and the health and welfare piece has been growing until this past year. And so what we were seeing is that the cash in lieu that was paid to them for the benefits really did become part of their living wage. And so for some of these lower level employees where the wages are not very high, if you're going to take away some portion of this $4.27 an hour and provide it now in benefits, that can have an impact on the monthly paycheck of your employees. So you need to be able to communicate that with them.
Yeah, and you know, what is a smart contractor supposed to do? I mean, we've talked, I think, a lot about these items, but I think just to review them and maybe recap them, take advantage of the Q&A process in the solicitation. You know, it's important to pay attention, ask questions. If you think if the wage determination is not there, ask those questions. You know, ask for information on the predecessor contract and the positions that were on the prior contract, the service positions, and how they were classified. Ask for a detailed description of work. I don't know if you'll get that. We all know that the Q&A process can be a dead end, and frequently is a dead end. But still, it's important to do that, including to make sure that you have an adequate description of the work that these employees will be performing.
If you ask for, say, a wage determination and the contracting officer still fails to do so, one thing that I have seen work for one of my contractors is that they actually specifically in their proposal stated that they believed that the work was SCA covered. However, in order to fully comply, they would need a wage determination. One was requested and not provided, and therefore that they reserved the right to come back and have an equitable adjustment should the Department of Labor determine that in fact a wage determination should have been provided. And I kid you not, in this case, the contract was signed, Department of Labor made the determination that it should have been covered, and a price adjustment was processed before the work even started on the contract. So, you know, you can protect yourself. If you think that the procuring contracting officer is making a mistake, put some language in there that would entitle you to an equitable adjustment.
Yeah, and particularly remember that employees, for obvious reasons, have an incentive to be paid more, and and employees tend to be savvy. They know what their rights are, and there's a good chance that employees will complain if they feel that you're not paying them according to the prevailing wage in the governing wage determination. So it's important to be proactive, and in the example that Jennifer just gave, I think showing the contractor's desire to comply, even in the proposal, is a very good step, because that, in a worst case scenario down the road, I think the Labor Department's going to see that the contractor was trying. Which can make a big difference. We mentioned before examining your labor categories carefully. It is really important to map these labor categories accurately. But in terms of the competitive landscape, an interesting strategy and something to think about is that, particularly if you're going up against an incumbent contractor, it can be difficult for some incumbents to lower their price when they have certain employees that are in higher classifications doing work that may be overclassified. They may not, they may have a certain talent or professional certification, but it may not actually be necessary, and so. Think about opportunities for where you may be able to meet the requirements of the contract if the actual work just doesn't require that higher classification. That may be a way to gain a competitive advantage.
And it's a challenge oftentimes for incumbents because you don't want to lose your existing workforce. They're the reason you're successful on the contract as a whole. But you need to keep in mind that just because you have bid them at those established wage categories does not mean that your competitors are going to, structure the workforce or use the same labor categories that you did. And so at the very least, you should be aware of the impact of that.
Yeah.
And we talked, again, carefully considering how you pay health and welfare. Are you going to pay cash in lieu? That's an additional employer cost. Yet you also need to keep in mind that failure to provide coverage could result in fines and penalties. Those are going to be unallowable. They're not going to be billable to your customers. So you need to take a look at all of the requirements that you need to comply with and figure out what's the most strategic and cost-effective way for you to comply with these different rules. I think the next slide we've got is minimum wage. So this is an older order. It was effective with new contracts issued after January 1st of 2015, and it required contractors and subcontractors to pay a minimum wage for work on SCA and DBA contracts. It did apply to also not just your direct workforce, but folks that perform work on or in connection with. So an example that was in the Q&A is a security guard who's guarding a building for a covered contract. They could be subject to the minimum wage. Here in the D.C. area, we think, $10.20 an hour, everybody makes more than that. But the reality is that especially out in the middle of the country, I think at one point Department of Labor estimated that there were something like $236,000 or 36,000 employees who were impacted by this rule. One little tricky thing that's there is that the wage determinations may still show an hourly rate that is less than $10.20. There's a footnote at the bottom that says that this rule applies, and that so even though the wage rate may show in the column $9 an hour, you still need to be paying them what is now $10.20 an hour. You can do a price adjustment for your contracts. For every year when the wage rate goes up. It started at $10.10, went to $10.15, $10.20. This is a separate price adjustment for each contract that would need to go through each contracting officer within 30 days of January 1. So it is a little bit of an administrative hassle, and you need to figure out whether it's worth it for you or not to go after that.
The other related rule that we'll just mention briefly, and you ought to see in any SCA covered contract, is the non-displacement of qualified workers clause. And this is essentially the right of first refusal rule. There's an executive order at the beginning of the previous administration. It took a few years for the rule to go final. But essentially this is an obligation on service contracts that you have to offer predecessor service employees the opportunity to retain their positions, and you have to give them a good faith, bona fide offer of employment. It has to be in writing, and you have to give them time to accept that position. So, in fact, I believe it's 10 days. You have to leave the employment offer open. So there is some process here. You can't just go in and ask someone on the spot as a new contractor and think you've complied. You've got to give the predecessor service employees a legitimate opportunity to retain their positions, or and this is a sort of a subtle point in the rule, it can be a different position. So the idea is that you are preserving the employment of and continuity for service employees, and there are different rules. We don't need to get into all of those, but you don't have to hire everyone. And if the previous contractor had 100 employees and you submitted a proposal for 75 employees, obviously you're not expected to, and you're not required to keep all 100 predecessor employees on. So there is quite a bit of flexibility in the rule, but it is something to keep an eye out on. Something else that I would also just mention, and sometimes you do see this, this rule applies for service contracts. So I think we've both seen some situations where a solicitation may have this rule only, but no SCA clause or no other or the price adjustment clause. Which would be in conflict. But it creates a challenge for you as a contractor, because the inclusion of a non-displacement clause is an indication that the government considers this to be a service contract. So that should certainly, at a minimum, prompt a question, and depending on the facts, potentially even a challenge to that solicitation.
One thing that, it's a little point, but the rule actually does prohibit additional screening. So you cannot drug test an employee, and if they fail it, refuse to give them a job under the non-displacement rule. So you are restricted to your additional screening. We'll run through a couple of other things just really quickly here. The good news is that Fair Pay and Safe Workplaces, the blacklisting rule, that was revoked by Congress. So fortunately, we are not, one of the concerns that we had under that rule was that even if it was the contracting officer's mistake that resulted in the back pay, that counted as a violation that you would have to disclose. So that's good. We don't have to deal with that anymore. Method for Department of Labor has issued an all-agency memorandum that they are going to develop the SCA WDs differently. There is some thought that this could have an impact on existing wage rates, so we're sort of waiting to see the impact of that. And then the big one here is the paid sick leave executive order. It is effective for all new contracts that were issued after January of this year. So if you have an SCA covered contract and you've got the SCA clause on a new contract, you should see this clause there as well. You have to provide additional sick leave in addition to vacation and holiday, so it may change how you're complying with your health and welfare practice. If you used to provide sick leave and you counted that as part of health and welfare, you now need to, you can only count it if it's above and beyond.
Yeah, I think at this point we'll just turn to a couple of questions, and if there are any at this point, feel free to submit the questions, and if we can, we will try to answer them. One of the questions that was asked earlier, I think we may have addressed it, but the question related to whether or not if the health and welfare requirement was increased in the middle of contract performance from $4 to $4.27. How does that work? And that goes back to the price adjustment clause. If let's say you're performing a contract and you're now in month 10, you're in the 10th month of the contract, and then there's a new wage termination is issued. You do not have to comply immediately. It's when the first anniversary date of the contract. So if it's the 1 year base period, for example. So you start January 1st, and then you perform it with a $4 health and welfare requirement. But then let's say on October 1st, the Labor Department issues a wage termination, increasing that to $4.27. You don't have to pay that yet, but when the wage termination on the anniversary date, the new wage termination should be incorporated into the contract, or if that's an option period or whatever it may be, and that's when your obligation would begin.
Right. So you need to make sure that the contracting officer is modifying that new wage determination into your contract. I do have cases where I see wage determinations out there that have health and welfare rates in the $3 range. So the contracting officer has failed to do their piece of the responsibility. And as long as typically the contractor is somewhat protected as long as they've requested some of these things in writing. There's also a question about whether SCA applies to federal contracts and grants that include the clause, or is it all contracts absent the exemption. The contract needs to have the clause and the wage determination for you to have something to comply with. However, just because it doesn't have the clause and the wage determination does not mean that the Department of Labor cannot come back at a later point in time and require you to comply. We've also been asked, does the SCA apply to interns? The answer there is yes. And does it apply to R&D contracts and SBIR contracts? Unless it meets one of the other exemptions that was specified there, it does apply. So, the clauses should be there. That, again, you may not see it because you may have contracting officers who are unaware of the requirement. But the big thing with those R&D contracts and where you may end up where there is an exemption would be on the mix of the workforce performing. They would have to be, above the 20% of non-exempt employees in order for it to really apply to them.
All right, and with that, we're going to wrap up today's webinar. We thank you very much for your time and for participating.